Well, hello everyone, and welcome to the latest in this series of Practico's podcasts, formerly known as Cost Chat Between Friends. The usual suspects are here, that's to say myself, Jeremy Morgan, KC, retired KC, and consultant to Practico, and Andy Ellis, the managing director of Practico. And we're very pleased to welcome for the first time well-known cost barrister Martyn Griffiths of Gatehouse Chambers. And so nice to have you as our new friend, if you like, in this series. Today is going to be mainly about Solicitors Act, which sounds incredibly technical and boring, but you have to remember this. What we're really looking at is what solicitors need to do to protect themselves against some unpleasant surprises when they've done an awful lot of work for a client and things begin to go wrong. And there have been a number of decisions which Martyn's going to look at in that connection. First, though, we're going to kick off very briefly with an update on PACCAR, and I'll hand over to Martyn to give you that little piece of news.
Thanks very much, Jeremy, and thank you very much for having me on. It's nice to be included in your costs friends. I've been a keen view of your podcast for a while, so it's nice to make it on. As you said, Jeremy, we planned not to cover PACCAR because obviously there's been a lot said about it of late, but it seems that we can't do anything in the cost world at the moment without running into something of importance in relation to PACCAR. This is really just a confirmation of a previous decision of the Court of Appeal, which is the Diag Human and Volterra Fietta decision, which I'll mention in a moment in a bit more detail. But the piece of news that we've had is that the Supreme Court has refused permission to appeal in relation to that. But it's a case that does have potential implications for the ongoing back between funders and those who have taken out funding from them. The Diag case concerned a discounted CFA, which was deemed to be unenforceable, where solicitors then went on to argue that they could sever the success fee so that they could be paid on basically a standard discounted hourly rate basis throughout. And so the case, as it got to the Court of Appeal, solely concerned the severance argument. And the Court of Appeal rejected the severance point, and it did so on two bases. The first, which is of perhaps limited interest from a funding perspective, was on the classic test in Beckett and Hall that the severance point would have defeated the original bargain and meant that the parties would have entered into a conventional retainer, not a conditional fee agreement, and that was too far removed from the bargain that the parties had entered into, and so therefore severance wouldn't have been allowed on any basis in any event. But the Court of Appeal went further in Diag and commented on the policy basis behind what they were being asked to do, and said that it would be contrary to public policy for an unenforceable CFA to be held to be partially enforceable. And in her judgment, Lady Justice Andrews pointed out that there would be little incentive to solicitors to follow regulations if their worst case scenario was that the offending terms could be severed and they would get a lighter version of the bargain than they would have got if the severance hadn't occurred. And so therefore it was held that the severance wasn't possible, and there was an argument running parallel for a quantum merit, and that argument was also dismissed. So as far as that relates to PACCAR, it's not binding as such, but it's going to be persuasive, and it's likely to be cited by any parties caught up in an argument about severance of a PACCAR funding agreement that is now deemed to be a DBA. I'm sure funders will argue that they're in a very different position because they will have made loan payments out rather than having provided a service for free, as solicitors effectively would have done under an unenforceable CFA. And I'm sure that they will argue that they're in a position once removed from solicitors who are officers of the court, and therefore they shouldn't be held quite so strictly to the public policy considerations that the court held there. But clients on the opposite side, or those who are seeking to take advantage of an unenforceable DBA, are likely to argue that the DBA regulations are just as strict a regime as the CFA regulations, and therefore the legislature must have had similar intentions. So I think it's a point that we're likely to see run on arising out of PACCAR, and what parties are going to do with the clauses that they're faced with in those funding agreements.
And just to make it clear for those who are following the debate generally, that case, the Diag case, was of course an attempt to rewrite the agreement after the whole case was over. So, you know, it's completely executed in traditional language, whereas there are plenty of attempts being made at the moment to rewrite DBL, third-party funding agreements, at a stage when the proceeding, which is still executory. So those are, in principle, possible. And it doesn't mean to say that if you've made a mistake, you can never rewrite it. You have to do it before the agreement has been executed, put it that way.
Absolutely. It's once your cost liability is crystallized, you can't then go back and rewrite your agreement to get to something more favorable or more in compliance with regulations. But if you've got an ongoing matter, it is possible to look into the terms of that and adjust the terms. But
you need the advice of expert cost counsel to get that right.
Absolutely.
That then is our brief reference to PACCAR. Moving on to the Solicitors Act and solicitor and client matters generally, there is an important Court of Appeal decision that Martyn's going to talk about, which concerns assessments at the behest not of the direct client, but in this case of a beneficiary.
Absolutely. The case is Kennigan, Thompson, Snell and Passmore, decision from the start of this year of the Court of Appeal. And it's an important decision because it really opens up, at least for beneficiaries, the realm of third-party assessments, which for a long time had been thought not to add very much the protections in the Solicitors Act at all. The long-standing authority on the scope of the jurisdiction for third-party assessments was Tim Martyn and Aiken Gump, which was a decision of the Court of Appeal back in 2011. And so if I make brief reference there to what the Court of Appeal decided in that case, it was that effectively a third party was bound by a blue pencil test that was the furthest that the court could go. And Lord Justice Lloyd held that all that a third party could do on a third party assessment under Section 71 of the Solicitors Act was to eliminate items from a bill which were outside the scope of the liability itself. So Tim Martyn concerned a mortgage and the charges that were made out of that mortgage, but there were also fees included in the bill which related to an insolvency. So those sorts of fees could be excluded on the basis that they fell outside of the scope of the cost recovery clause in the mortgage. But that's obviously quite a limited situation and doesn't crop up in every case by any means. Beyond that, the court could also eliminate items which would only be allowable between a client and a solicitor on a special arrangement basis, applying the presumptions that are now found in Rule 46.9. But those would be on the same basis as between a solicitor and client. So you're bound effectively by the presumptions in Rule 46.9 as to what's reasonable or unreasonable, and that the court couldn't go any further in eliminating any other item or reducing the quantum of an item which had been properly included in the bill. So that's really
just that second exemption. There's a sort of case where the solicitor says to the client, look, this is just not properly recoverable under the terms of this clause, or has nothing much to do with the particular retainer. I'll do the work if you want, but you're going to have to pay for it. That's the sort of situation where
or the solicitor says, this isn't the sort of figure you would be able to recover for this work from the other side. If you want me to do it, I'm happy to do it. And the client says, yes, please, I'd like you to do that work in any event. The third party can't say that decision was one that it shouldn't have to face the cost of, because it is on that special arrangement basis that it's been approved, and it therefore falls within 46.9. The only way that it could be challenged is if the solicitor hadn't said that to the client and it was an item of cost that was presumed to be unreasonable as a consequence. So it's of a pretty limited scope. And really the important element of the Aiken Gump decision was that parties can't challenge ordinarily line items of the bill in terms of the quantum, the amount of time that it might have taken to do a particular item of work, which is obviously what the party would want to challenge where there had been excessive work done or duplication. And in fact, Lord Justice Lloyd himself noted that following his decision, third-party assessments were going to become much fewer as a consequence, that the court would be likely to see less of them. And that's exactly what did happen and has happened. And they've been a very rare thing indeed since then. But the Kennig decision was one that came up through from a cost judge Brown at first instance. And Kennig is interesting because the Court of Appeal confirmed that actually Section 71 relates to two discrete jurisdictions. It doesn't relate to one single jurisdiction, as had been presumed by Lord Justice Lloyd in the Tim Martyn decision. So they trace it back, and it's quite an interesting narrative for those who are inclined to look back on the way that the legislation has developed from the Victorian era. But really, the key thing is that there's Section 71(1), which deals with the cost liability of third parties, essentially under a contract, typically under a contract, such as in the circumstance of a mortgage, which was the Tim Martyn case itself. And Section 71(3) relates to beneficiaries who are going to have to ultimately be liable for costs that are paid out of an estate. And when you trace those back, those two jurisdictions, although they now appear in Section 71, actually came from separate provisions of the older versions of the Solicitors Act. And the Court of Appeal therefore said, these are two distinct powers, even though they've been put together in one section, and that Lord Justice Lloyd had elided those two things when he'd considered Tim Martyn. And so the upshot of all of that is that if you're in the contractual position, so you're somebody who's liable to pay pursuant to a contract, perhaps a mortgage, that's the classic example, then you're still limited by Tim Martyn and the blue pencil test, and a third-party assessment is unlikely to add very much unless there are extra items that are being included in the bill, as was the case there. However, if you're a beneficiary under a trust, and Kenny concerned beneficiaries under a will, then you do have a broader ability to attack the costs and to challenge the costs at a detailed assessment. So Lord Justice Stuart Smith upheld Cost Judge Brown's first instance decision that blue pencil test doesn't apply, and critically, third parties can make quantum challenges to items in the bill. So they can challenge items such as duplication in the bill and the amount of time that has been spent doing any particular item of work. And so it seems very likely that we're going to see an increase in Section 71 challenges in the probate sphere and where trusts are concerned. And I've already seen a lot of commentary pieces doing the rounds from colleagues who practice probate in the probate sphere, commenting on the decision as giving effectively beneficiaries new powers to hold trustees to account in relation to this. And particularly in the relatively common situation where you have trustees who are within the same firm of solicitors as those carrying out the probate work themselves. That's going to be an interesting area that I think we're going to see some more development in and more cases coming forward.
I mean, the facts underlying that case were quite interesting, because the difference between the estimate the solicitors gave for their work and the actual outcome in the bills was pretty dramatic. So you can see a strong case on the merits, if you like, for reaching that conclusion. I was particularly pleased to see it because that particular firm had actually drafted a will for me some time ago. And I thought, oh, blimey. But in fact, we went somewhere else, not for any reason connected with that, because we now live in a different jurisdiction. Just though, to look at it from the solicitor's point of view, what is the practical effect? Obviously, we've got three parties here. We've got the solicitor, we've got the client, in that case, the executor or trustee, and we've got the beneficiary. So is the solicitor, in this case, the case of the beneficiary, liable to have their actual bill reduced, as opposed to simply there being some adjustment between the trustee and the beneficiary?
I think that's likely to depend on the sort of costs that are being challenged and the work that's been done, and also the relationship between the trustee and the firm itself. I would have thought so. The classic example has always been that, and it's one of the reasons for the distinction between Section 71(1) and Section 71(3) has been the difficulty of reducing the solicitor's bill in terms of the assessment for the party who's challenging it, but then that work has been done and done properly. So how do you put those costs in front of the party who's chargeable? And so if you're dealing with special arrangement sort of costs, as we were just talking about, where a solicitor has said, or should have said, this is work that isn't really recoverable against the estate, then that will be for the liability of the trustee. But I think if you have a finding from a cost judge who simply says this item of work has been excessive and you've spent too long on it, and therefore that is going to be reduced, I think you'll probably find trustees pushing back themselves and saying, well, that's not a matter that I'm liable for. Of course, if that is in reality the solicitor's firm wearing two different hats, it won't make a tremendous amount of difference in any event, because it's an arithmetical exercise rather than anything else. But it's going to differ, I think, depending on which category of costs and which category of challenge the solicitor's dealing with. The real...
Sorry.
No, sorry, Jeremy, after you.
No, I was just going to tell an anecdote, which is, I mean, the importance of this is reflected in a case that I did when I was still in practice, which was quite a large estate, where the executors were the solicitor and the manager of the estate, if you like, the man who'd managed. It was a landed estate for many years. And I think it was at the funeral, they had a little meeting and decided to agree each other's hourly rates. And, you know, that's actually classic, but no, perhaps not classic, but very critical in a case like this, because then the solicitor can say, well, my hourly rates were agreed by the other executor. And so it's very important in terms of beneficiaries that the relief in this recent Kenny case is perhaps available to the beneficiaries in a way that it wouldn't have been under the Aching Gump case.
Absolutely. And I think one final takeaway for solicitors, it's a theme that runs through all Solicitors Act assessment work. It's the importance of keeping a client up to date and informed, whereas before that would have been limited to the trustee. If you can also provide that information to the beneficiaries or principal beneficiaries, where you have a relationship and a dialogue with them, then you're going to be able to persuade a cost judge on any assessment that your charges are more reasonable if they're informed, and you're getting informed consent as you go along. It's really the central nub of any Solicitors Act assessment. It wouldn't have been important before the Kenny case for beneficiaries, but now, other than as a matter of client care, as it were, but now it is an important principle of the Solicitors Act for third parties.
Moving on then from beneficiaries, not so much a Solicitors Act case, but a solicitor and client issue of a CFA that was determined early by the client, and what happened in that particular story. This is an SCCO decision, isn't it?
It is, yes. It's a decision of the senior cost judge in Sellers and Simpkins towards the end of last year. And it relates to a relatively common sort of situation where solicitors have been instructed under a CFA. This was for a personal injury case. And the client decides at some point during the life of that retainer, actually they'd like to instruct other solicitors, so they terminate the first CFA and move off to another firm. In this particular case, the CFA was a CFA light, so that there was a capped liability within the CFA that said the solicitors would take no more than the fees recovered from the other side. And it was a CFA without a success fee. So there was a 0% success fee that had been included. The claim itself was compromised at a joint settlement meeting, but it was only after that joint settlement meeting that the original solicitors delivered a bill, and their bill was for their full costs without reference to anything that had been agreed at the settlement. As I understand it, the joint settlement meeting had agreed a global position for the fees. And so the argument came before the court as to what that meant in terms of the solicitor's recovery. Were they capped with the liability that they should have had? And the important terms of the CFA were firstly that capped liability, and secondly, the termination clause that stated that if the client terminated, the solicitor had the right to elect two bases of payment. They could be paid straight away, regardless of outcome, their fees and disbursements, or they could wait and be paid on the basis of the outcome of the case, which would have been their fees if the case was successful, plus the success fee. should obviously, in this case, be set at 0. And so the argument came up that effectively the client argued the opposite to what they would perhaps ordinarily argue, that the solicitor had decided to await the outcome of the case, and therefore was capped in terms of their liability, because they shouldn't be entitled to have more than had been agreed in the settlement with the other party under the cap. And it was held that the overall cap didn't apply where the solicitor was had their retainer terminated early, because the solicitor obviously at that point, if he delivered a bill straight away, couldn't know what that liability would be capped at. So he's entitled to deliver his bill for whatever sum. And the further argument that was advanced, that the late delivery of the bill after the termination meant that the solicitor had actually, as a matter of fact, decided to await the outcome of the case, was also rejected. The judge held that you didn't need to have the delivery of the bill as the item, as the matter that triggered that liability, and the correspondence in which the solicitor acknowledged the termination and said, we need to resolve costs before I'm prepared to give the client the file, was sufficient for the election for those purposes to be paid straight away. And the way that the judge dealt with it was to say, if the boot had been on the other foot and there had have been a success fee, had the solicitors come in front of him arguing that their success fee was recoverable because they decided to delay delivering a bill, that argument couldn't have succeeded, because they'd have effectively been trying to ride two horses, because they could have relied on this correspondence, had the case failed, to say they wanted to be paid their standard fees, and awaited the outcome and said, well, actually, we delivered our bill at this point. And the judge said, no, that's not an appropriate way of dealing with it. There's no cap on the solicitor's fees, because they said that they needed to sort out payment straight out of the termination. That was their election. They'd have needed to have said something much more express if they were going to await the outcome of the case. And so that was the decision there, and the solicitors were entitled to be paid on an uncapped basis.
Stick or twist, as it was put in the argument, which I rather liked as a way of expressing it.
Stick or twist. And here, of course, one of the factors that I'm sure made it much less attractive to the court was that they'd have been twisting for nothing. Yes. There was no upside to this particular gamble. So why a solicitor would have agreed to await the outcome of the case, having had their retainer terminated, is an interesting question.
And just to note, that was a fairly standard law society terms agreement. So this is going to be a decision which in practice would apply in a lot of cases. Yes,
absolutely. And there was reference made to a lot of the other law society terms cases, but particularly termination cases where a party has passed away and those sorts of things, as to how the term should be interpreted more broadly. So it is important, if you are using those terms, to be aware of those sorts of things.
Andy, I haven't brought you in earlier because you've got a nasty cold today. If you just nod if you've got nothing to add, but if you want to say something.
Thank you very much for keeping me even further in the background than I normally am, because I'm feeling very sorry for myself at the moment. But no, I think that was I didn't have anything to add on the beneficiaries case, other than I suppose challenging estate costs might become I suppose a sort of minority interest, but some sort of specialist area, particularly as sort of with the rising property prices, estates have got larger, and the beneficiaries, once they get alive to what they might be able to do, they might be more inclined to launch challenges. Of course, with the caveat that I suppose there's a bit of a fishing expedition sometimes at the beginning of to really understand whether one might have been overcharged or not. And when you've got to get a fifth off to get your costs of the challenge, it's the cost benefit analysis of launching a challenge is one that has to be taken very carefully. But just skipping over to this one, no, I think it's that seems to me to be a very just decision. I always think it's very unfair on solicitors who've entered into CFAs if they get replaced, that they might be subject to something that they've got no influence or control over later on. It also is important when there's changes of solicitors. It always challenges if inter partes costs become recoverable normally, as opposed to wrapped up in an all-up deal. Who's going to bear the if you like, the cost of change, as it were? Where does that come in? I mean, and I always think chronology makes sense here, which is it's the new solicitor, or the client shouldn't be recovering the cost of the new solicitor reading in. It's that level of duplication that normally gets chopped off, and the original solicitor's work is the one that stands up if it ever comes to it.
Yeah, absolutely. And it's obviously a point that you often see on inter partes assessments, where the paying party says at the end of the proceedings, if there has been a change of solicitor during the course of the life of the retainer, that additional cost isn't something that they should have to bear, and quite properly so. And then it's a matter for the solicitor and the two firms of solicitors to discuss. And ultimately, as you say, if the client has made that election, whether for good or for ill, as the case has turned out, then it's for them, really.
Thank you. I shall retreat back into the shadows until later.
But your reference to the 1/5 rule segues very nicely into the next case, which is about Part 36 and Solicitors Act assessments.
Yes, well, as is often the case with Solicitors Act work, points that have been long speculated over take quite a while, or have historically taken quite a while to be answered. And this is a question that has gone really back to the 2013 Jackson reforms and the extension of Part 36 to detailed assessment, which we know on an inter partes basis it is a powerful weapon. And in Zuri and Vardag's, cost judge Leonard dealt with the question of whether a Part 36 offer was applicable to the circumstances of a Solicitors Act assessment. And the long and the short of the case is that he held that Part 36 doesn't apply because you have Section 70, subsection 9 of the Act, which provides for the 1/5 rule. And effectively, the judge found that you can't have secondary legislation in the form of the civil procedure rules trumping the standard position in the legislation, and to therefore introduce Part 36 as an additional caveat. But the facts of the case are interesting, because it doesn't mean that Part 36 is entirely useless to parties in the Solicitors Act realm. So the case, as is so often the case with Solicitors Act work, commenced as Part 7 proceedings, where the solicitors sued for their outstanding fees. And the case was then stayed so that the solicitors and the client could have an assessment, which itself was stayed so that there could be an attempt at ADR. That attempt came to nothing, and so the assessment was restored, and the solicitors made the Part 36 offer that ultimately came before the court. On the facts of this case, the client completely disengaged, it appears. So they didn't attend the assessment and didn't make any points in relation to this argument. The solicitors recovered, I think, 98% of their bill and beat their offer. And so the solicitors tried for the uplift on the Part 36 offer. And that was how the case came before the court. And Cost Judge Leonard said that Part 36 didn't apply, as I've already mentioned. But two areas where it could be deployed or potentially deployed. He held that had it been the case that the solicitors had their bill reduced, they could have deployed the Part 36 offer for an argument of special circumstances that the 1/5 rule shouldn't apply. So in circumstances where a Part 36 offer had been made and engaged and a party hadn't accepted it, that could be used against the 1/5 rule in the same way as a call-to-bank offer might be used to say that that's all very well and good, but this should give rise to a different costs outcome to the standard costs outcome. And he also noted that it wasn't for him to consider whether the Part 36 offer might be relevant in the Part 7 proceedings themselves. So if you have cases that have got a reasonable amount of costs churned up on the Part 7 proceedings that have been stayed for an assessment, then the Part 36 offer may have some potency there. So it'd be interesting to see whether that case crops back up, whether there's any record of that case cropping back up in relation to the Part 7 proceedings and where that comes out there.
Well, and is that likely to be definitive, this view on Part 36? I got the impression it probably was.
That's my view. The speculation had always been that there were lots of difficulties with Part 36 applying to the Solicitors Act. And it's very strongly persuasive and very well-reasoned judgment as to why it shouldn't apply. And there are additional reasons that I've not gone into here concerning the scope of Part 46 and Part 47 of the Civil Procedure Rules, based on some of the other decisions in related areas. So I think it's very likely to be followed by the other cost judges. But the same thing always applies really for solicitors to bear in mind if they are dealing with an assessment, the potency of the 1/5 rule, but the ability to make offers around that as well, if to the extent that it's necessary to do so, to affect that position on an argument at the end of the case.
Any thoughts there, Andy? A very practical area.
Yeah, no, I think it's I think it's a well-reasoned decision. I think it must be right that trying to get yourself Part 36 protection. It is a protective measure. It's a sort of, it's a shield, not a sword, I suppose, to use that old sort of trope, But my question really is, on the basis that technically Part 36 doesn't apply, to me, the better way to make that protection would be through framing it as a quarterbank offer without prejudice saves the cost of assessment, rather than actually try and put a Part 36 label on it, because it would have just as much, like if it's in the correct form or a very clear form anyway, it's going to have as much help to you as trying to call it Part 36 in that situation. If you've made an offer that's slightly below the 80% threshold, so to accept payment below that.
Absolutely, and it also gives the parties greater scope in terms of the terms potentially that they want to introduce there. And what I had seen as a matter of practice before this point had been determined was a lot of cost lawyers and solicitors who dealt in this area a lot were tended to make two offers in very similar terms, one on a Part 36 basis and one on a Calderbank basis, so that if there was no acceptance of the offer, there was the potential to make this sort of argument for Part 36 as an additional benefit if the argument came off. And it may well be, I don't know, may well be that was the basis of the Vardag's decision, that it was included because it was worth a punt to see if there was an additional benefit that was available. But a Calderbank offer may have been made alongside.
But likewise, my only other little snippet on that, I suppose, is that if you can't use Part 36, you don't get some of the problems that Part 36 brings with it. Like Part 36 offer doesn't expire; it can be accepted at any time unless it's expressly withdrawn, and so on and so forth. So I think the solicitor has a little bit more scope if they go the Calderbank route rather than the Part 36 route.
Absolutely. And it means that you can change your offer position as you move forward if you're making Calderbank offer as the case develops and changes, as you say, without having to formally withdraw it. The only thing to bear in mind, as ever with offers and withdrawing them or having offers expire, is the potency that the court will apply to that and look at that with when it comes to considering the position at the end of the case. If you are arguing for a different cost outcome, you need to be able to persuade the judge that there are special circumstances and that offer really ought to have been reasonably acceptable at that point in time, as opposed to it being entirely in retrospect. And the longer that an offer is open for, the more likely you are to be able to persuade a judge of that.
I mean, I suppose it depends. That would depend a lot on timing of the offer, because so therefore, arguably, an offer made after the client has had right of inspection of the papers and so on and so forth would probably carry more weight, because the client would then be better informed as to whether they should be accepting it or not.
Yes, absolutely. Although if you make a well-judged offer before that point, then you can always say and you leave it open, you can always say to the judge, well, they had the opportunity to consider the file and come back to this offer. I'd always encourage parties to think about making offers where it's commercially viable to do so, to try and keep me out of work and reduce the cost of the assessment.
I suppose the other thing, standing back, we talk from time to time in these chats about reform of the Solicitors Act, which we always agreed is fairly unlikely to be a major priority for any government at the moment. But if there were a reform, would it be worth looking at the 1/5 rule? I mean, it's quite rigid, isn't it, and rather inconsistent with the modern approach to flexibility which can come from Part 36 and Calderbanks. Any views on that?
I think for my part, that one of the things that the cost judges I think quite like about the 1/5 rule is the certainty that it gives parties from an early stage. So in some senses, the rigidity of it provides an early warning to clients who want to make an application for a detailed assessment. They know the hard and fast position that they have got to get to, and 20% off a bill is quite a large portion to get off a bill. So it is useful when, certainly when advising clients, and I do solicitors at work on both client and solicitor side of it. It's quite useful to be able to say to a client, you do need to get a good amount off. It's not going to be a straightforward matter of reducing some items and being able to get your costs of this. This could become a very expensive exercise. And likewise, when you're for the solicitors, reminding the other side of that fact is quite useful. So having the hard and fast rule, although there isn't the amount of flexibility there, I think it is useful.
Okay, just moving on, we've talked about a number of aspects of solicitor and client billing and assessments. Any sort of general advice and things to take away from that discussion?
Well, I think just generally stepping back, because and looking at the Solicitors Act world, as it were, and the amount of challenges that we're seeing. When I've been practicing accost for about 8 or 9 years now, when I started out practicing in this area, the Solicitors Act assessments were things that you read about more than you experienced, and now they make up a very large portion of the work that's happening over in the SCCO, and probably about 50% of my cost practice is spent on Solicitors Act work by comparison to inter partes work, and so there has been a real growth there, and it's a salutary warning for solicitors, I think, seeing that growth, that they ought to be very carefully thinking about how they can protect themselves in the life of the litigation, really before it gets to the costs department and before it gets to looking at recovery of fees from clients or former clients. It goes right to the heart of the case. And there are some things that I'm frequently seeing coming up that happen on virtually every Solicitors Act assessment that it is worth solicitors being aware of. So the first is going right the way back to the retainer. Most solicitors have included in their terms terms that attempt to try to get interim statute bills as the basis on which they are billing their client. And the reason for solicitors to do that is to provide certainty and to reduce the applicability of the scope of the Act. But the important thing for them to be aware of is that because it reduces the time frame in which a client has to challenge the bills, and I'm sure that most of your viewers will be aware of this, but an interim statute bill is a bill which pertains to a particular period of work and is final and starts the 12-month period for assessment running there and then during the life of the case. So it's a powerful thing for a solicitor to determine that they're certainly going to get paid and the assessment in there. And it is, but the flip side of that is it creates a difficulty for a client who is running an ongoing case, because they're effectively put in a position where they have to choose to challenge their own solicitor's fees at a time that they may well be litigating and fighting the other side quite hard. Because of that, cost judges, when they're looking at retainers, aren't a fan of that form of billing, and so it has to be put in the clearest possible terms and explained to the client that these bills are final bills, so that the client can then exercise their right to assessment. And quite often you see retainers that have perhaps been tweaked over the years or drafted by committee that don't consistently set out the position in relation to that, and don't plainly tell the client that they are final bills to the period or the element of the work that they relate to. And therefore there are arguments as a preliminary point almost always on an assessment over whether those bills are valid interim statute bills, or whether or not the client is entitled to have a new bill delivered and attack all of the fees that the solicitor may have had over the life of the retainer.
Any other things particularly? I mean, obviously that's a very important issue. Any other things to be aware of?
I think from a conduct point, the other point that comes up as a preliminary point very, very often is the importance of solicitors' estimates. Obviously, we know that there's the regulatory side of that, where solicitors are under obligation to give the best cost information that they can to their clients in any event. But quite often you see cases where there's an early stage estimate that is necessarily quite a broad ballpark estimate to the sort of cost that could be expected in a typical case. And it is quite common to see included either in the client care letter or in the terms themselves a provision that says something to the effect of, and of course we'll keep you updated as we go along, or we will let you know if at any point we're likely to go through the top of that estimate, or words to that sort of effect. And once a case is up and running, it's quite rare that you see that actually happening, because everybody's preoccupied, quite rightly, in some senses, dealing with the case that's at hand. And then there ends up being an argument about what that means for the estimates at the end of the case. So I think it's important to firstly set out what you're going to do with estimates and stick to it. If you are going to provide regular periodic estimates, then you can put that in, but I wouldn't be putting that in my terms if you're not actually going to follow through with it. But you do have to keep the client updated about the estimates as the case moves forward and how the case changes, as a general position. And then a point that arises out of that I'm seeing increasingly argued is the use of cost budgets from a party's proceedings as a sort of quasi-estimate. So where solicitors aren't giving regular updates to estimates and a budget appears at the CCMC stage of the litigation, clients then saying, well, I had a reasonable expectation that this was the budget, in inverted commas, and therefore it sits as some sort of estimate about the amount of costs I could expect, and look at how far and above the budget we've gone. And there was no application to amend the budget, and I wasn't advised that there should have been an application to amend the budget in the main litigation. And there are attempts to effectively treat a Preston H as a quasi-estimate. And quite often that situation is made worse, or is given more credence, where solicitors send emails alongside the report back from the CCMC to the effect of telling their client that we've had a very good outcome at the CCMC because we've recovered, in inverted commas, 85% of our budget that the other side were trying to knock down. Now, of course, we all know what that means. The case has been budgeted at 85% of what we wanted it to be. But quite often clients come back at the end of that saying, well, I was being told that this was a really good outcome, and nobody's explained to me the difference between what that outcome is on an inter-parties basis and what that actually means for the case moving forward for me, and what my liability is to pay my solicitors. So I think keeping a hard and fast distinction between those two things in the emails reporting back to clients, and a reminder alongside anything to do with the inter-parties budget that isn't the liability to the solicitors, that's what you can recover from the other side as a contribution to that liability. It is a really important point.
Absolutely. Andy, anything to add on these practical points?
No, I thought Martyn covered it really well, and I was particularly interested in the practical problem of needing to, if interim statute bills are allowed under retainer and produced during the course of a retainer, the idea of having to sort of battle on two fronts as you go through as a client is very difficult, and for the solicitor is very difficult. So without having really formulated it properly, I can understand why the solution might be that interim statute bills operate as a cap on the solicitor's ability to charge the client for the work done in that period, but that there's some relaxation depending upon the circumstances as to whether you can open up earlier bills in terms of a challenge, depending upon what the nature of that challenge is at the end. Because on the other side, you have to be very careful that the client is really more motivated by a suboptimal result of a litigation rather than actually a dissatisfaction with the level of fees as they were going through and the level of information they were given about those fees as they went through. So it's a tricky situation, but it's a tricky relationship, because we all know it is a very expensive business going to court, and it's also difficult to it's very difficult to predict the outcome. It's very difficult to it shouldn't be difficult to monitor expenditure in real time, if you like, without too much of a lag when you're reporting to your client. But that doesn't necessarily translate to constantly having to update what the knock-on effect of those incurred costs are as to what will happen before the end. That just all gets wrapped up in the uncertainties and vagaries of litigation, unfortunately. And at least, as we always say, as in being in the legal business, solicitors are held to a much higher standard and clients have much stronger rights than they do against some other professionals, accountants are the normal ones that are mentioned. So although this isn't people will be getting out the smallest violin in relation to the legal profession, there are protections there.
It's definitely true. It's a difficult balancing act for solicitors to strike, and in sounding these warnings, I'm not trying to make little of that, because it is difficult. And I've dealt with one case a couple of years ago where there was actually a huge amount of cost information that was provided to a client as the case went along, and there were contemporaneous documents effectively saying things to the effect of, "Please don't bother me with this. Why are you sending me this again?" An argument raised towards the end of the case that was so much information provided that actually the client was snowblinded by it all, that she had so much cost information provided that it made it very difficult for her to keep track of. And so there is a balance to be struck. And I think, Andy, you're absolutely right to say that there is a correlation between the satisfaction of a client as the case goes on, and then the level of satisfaction based on the outcome of the case. Certainly you tend to find, not always true, but you do tend to find that clients who are bringing Solicitors Act assessments have had some level of disappointment in the underlying litigation, regardless or entirely separately to the level of service that they might have had. But that's all the more reason why solicitors should be very carefully thinking about the terms of their retainer and protecting themselves as the case moves forward. And we just one final thing on that is that as we move into this fixed costs world where more and more cases of a higher value are going to be attracting fixed costs, there's going to be greater and greater shortfalls in terms of the solicitors' recovery for their client of the costs and what the solicitors are going to be charging their client. And so I think we're going to see, particularly where there are marginal results in the main litigation, more disgruntled clients coming forward with Solicitor Act assessments, because the commercial result that they have got, taking the entire proceedings as a whole, isn't what they originally wanted. And therefore, if a solicitor hasn't adequately protected themselves, there's a target there to improve that commercial outcome.
Exactly. I completely agree with that. I mean, and it really emphasises the fact that it's not the overall most of the time for the client that's a concern. It's the net position, isn't it? They can be sort of, they're more concerned. They may think the costs are too high, but they would want to keep their powder dry a little bit in terms of challenging it. Because if they do get most of it back, or 75% back from the other side, then that's going to affect their appetite to fight the solicitor in relation to shortfall. But you have to kind of pin your colours to the mast a little bit. I don't know if you've had a situation where, as we have sometimes or coming up to an assessment, where we've had to say, well, look, if the client's moaning about your bill at the moment, I mean, how do we produce an inter partes bill? And how do you sign the indemnity principle certificate in terms of liability? You've really got to sort that out first, because you can only present to your client to the other side what your client's agreed to pay. Conversely, the client might want to say, well, I want to see how we get on. And so that can become a little bit circular.
Yeah, absolutely. As I said, going back to that point about budgets being treated as estimates moving forwards, obviously those sorts of conversations that are being had with the client at that point, where draft budgets are sent over, are really, really important, because they're likely to be the sort of documents that are relied upon if you get to the point of an argument about a Solicitors Act assessment, or an argument about special circumstances to whether there should be one. So it's really important to make sure that those conversations are really clear in terms of the information that you're giving the client about that.
Just picking up on a point that Andy made about the sort of human element, in practice, I've come across situations where the client, faced with an interim statute bill, had this impossible choice. I get on very well with the solicitor, but these costs are very high, and I really don't want to have to pay them. Do I take them on at this stage? And if so, what's going to happen to my case? And really, really worried about it. And you worry with them, because you think, yeah, you're absolutely right. That's a risk. And on the other hand, solicitors who've sent in a series of interim statute bills, or what they thought were interim statute bills, and the client saying they want to open up the whole thing for the last 5 years, of litigation when the solicitor's done a brilliant job and done everything that they've been asked for. And they're saying, how can they possibly challenge it at this stage? You know, it's just not right. So there are moral dilemmas on both sides. Look, with that unhappy prospect of perhaps more Solicitor Act challenges, particularly with fixed costs being extended, I'd like to thank you very much on behalf of Practico, Martyn, for that really clear explanation of this area, and to thank all of those who are watching and wish them well and invite them back for the next podcast.
Thanks very much.
Thank you.